Introduction to this portion of the course. Real estate business practice begins long before a property ever appears in the MLS or a sign is installed in the yard. It begins with the legal foundations that shape how real estate professionals form relationships with the public, create obligations, and establish the authority to act on behalf of a client. The learning objectives in this chapter focus on understanding how listing agreements are built on agency law, contract law, and the professional responsibilities you have studied in previous chapters. In earlier lessons, you examined agency creation, fiduciary duties, standards of care, disclosure responsibilities, and the legal elements that make contracts valid and enforceable. Now, you will tie these concepts together and apply them directly to one of the most important documents in real estate practice, the listing agreement. A listing agreement is not simply a permission slip to advertise a home. It is a legally binding contract that authorizes a real estate broker to act as an agent for compensation. When a seller hires a broker, the relationship simultaneously triggers the principles of agency law and contract law. Because of this dual nature, the listing agreement becomes the central framework that governs how the transaction begins, how the broker must perform, and how compensation is earned. Review of legal foundations, agency, and contract law. The listing agreement sits at the intersection of two major legal structures, agency law and contract law. These frameworks govern how the relationship is created, what duties are owed, and what happens if one party fails to perform. Understanding these principles ensures that real estate professionals operate with clarity, legal compliance, and protection for both themselves and their clients. Agency law. Agency law governs the relationship that arises when a principal authorizes an agent to act on their behalf in real estate matters. In a listing agreement, the principal is the client, usually a seller or landlord, and the broker is the agent. Every concept you previously studied about fiduciary duties, obedience, loyalty, confidentiality, disclosure, and accounting applies the moment the listing agreement is formed. Parties to the listing agreement. The listing agreement establishes the relationship between the real estate broker and the client. The broker is the fiduciary and the client is the principal. Any buyer, tenant, or prospect on the other side of the transaction is considered a customer. If another salesperson or broker assists the listing broker in locating a buyer, that cooperative person acts as a subagent of the listing broker unless they represent the buyer in a separate agency relationship. For example, if a salesperson in the same brokerage as the listing agent shows the home to a buyer, that salesperson is not the seller's broker independently. Rather, they are acting through and under the authority of the listing broker. In Arizona, this framework becomes even more important when evaluating whether limited dual representation arises, whether consent forms must be executed, and whether fiduciary obligations shift or remain exclusive. A listing agreement therefore determines not only who is represented, but also who is not represented, and it shapes the duties owed to each party. Fiduciary duties arising from the listing agreement. The listing agreement immediately creates a fiduciary relationship between the broker and client. From that moment forward, the broker owes the client absolute loyalty, obedience to lawful instructions, confidentiality, reasonable skill and care, full disclosure of material facts, and accurate accounting for all funds and documents. These duties must be upheld through the entire listing period, regardless of how the transaction develops. For example, if a competing offer comes in that materially benefits the client, the listing agent must disclose it promptly, even if doing so complicates the negotiation process. Likewise, if the agent notices a safety hazard in the property that could impact the outcome of the sale, the agent must bring it to the client's attention, even if the client did not request it. A listing agreement does not authorize the agent to bind the client to a contract or present terms of acceptance on behalf of the client. For example, an agent cannot tell a buyer that the seller will take the offer no matter what. unless the client has explicitly granted such authority in writing. Acting outside these limits exposes the agent to liability, potential loss of commission, and disciplinary action. Scope of authority under agency law. Listing agreements typically create a special agency, meaning the broker is authorized to perform specific tasks necessary to procure a buyer or tenant, but is not given full authority to act as if they were the principal. The agent's authority is limited to marketing the property, coordinating showings, presenting offers, and advising the client. The client retains the exclusive right to make all contractual decisions. For instance, the agent may recommend accepting an offer, but only the client may legally accept it. If an agent exceeds their authority by committing the client to terms without permission, the agent may breach fiduciary duties and face consequences. Under agency law, the principal is responsible for the actions of the agent as long as the agent acts within the scope of authority granted by the listing agreement. However, the client is not liable for unauthorized acts. If an agent promises a buyer that the seller will include personal property in the sale without the seller's approval, that agent has exceeded their authority. The seller is not bound by that promise, but the agent could be held responsible for misrepresentation. Contract law. The listing agreement is also a contract, and therefore it must meet the elements of a valid contract. It must include mutual consent, consideration, legally competent parties, lawful purpose, and specific terms regarding compensation, duration, and scope of services. A bilateral or unilateral agreement. A listing agreement may be bilateral or unilateral, depending on the type of listing. An open listing is unilateral because only the seller is making a promise to pay a commission to the broker who produces the buyer. The broker is not obligated to act, and the seller may sign open listings with multiple brokers. Most exclusive listings, however, are bilateral. In an exclusive right-to-sell listing, the seller promises to compensate the broker if the property sells, while the broker promises to actively pursue the sale through marketing and professional efforts. Validity of the listing agreement. For the listing agreement to be enforceable, it must meet the requirements of a valid contract. It must clearly state the property, the broker's authority, the compensation structure, the time period, and the signatures of legally capable parties. It must also comply with state-specific requirements. In many states, including Arizona, exclusive listings must be in writing to be enforceable. Written agreements prevent disputes, allow brokers to enforce compensation, and ensure all parties understand their rights and obligations. For example, if a seller verbally tells an agent to list the home for $450,000 and the agent obtains a full-price offer, the seller could later deny that the agreement existed. Without clear written terms, the broker may struggle to prove the relationship or enforce compensation. Written agreements eliminate uncertainty and create a clear evidentiary record of the business relationship. Termination of the listing agreement. Like any contract, a listing agreement may terminate through performance, infeasibility, mutual consent, rescission, revocation, abandonment, lapse of time, invalidity, or breach. For example, performance occurs when the broker successfully procures a buyer and the property closes. Lapse of time occurs when the listing expires on the agreed date. Mutual consent occurs when both parties decide to cancel the agreement early. If the client engages in conduct that makes the broker's performance impossible, such as refusing all showings, the broker may terminate due to infeasibility. If a client revokes authority without cause, they may still be liable for compensation if the broker procured a ready, willing, and able buyer before the termination. Legal form and writing requirements. Although a listing agreement may be oral or written in some states, written agreements are considered the professional standard and are legally required for enforceability in many jurisdictions. Arizona requires written listings for exclusive representation. Written agreements protect brokers by providing a clear basis for compensation and protect clients by defining the scope of the relationship. Oral listings, even if technically valid, are extremely risky. For example, if a broker successfully secures a buyer under an oral listing and the seller refuses to pay the commission, the broker must rely on witness testimony or circumstantial evidence to prove the agreement. If the client dies before paying, the broker may not be compensated because probate courts generally require written documentation to enforce financial obligations. Express and implied listings. A listing agreement may be created expressly or by conduct. An express listing occurs when the parties clearly state the terms, either orally or in writing. An implied listing may arise when the seller knowingly allows the broker to act on their behalf. For instance, if the seller hands the keys to a broker, approves showings, and accepts marketing efforts without signing a written agreement, an implied agency could be recognized. This may entitle the broker to compensation and may obligate the broker to fiduciary duties. Assignment of listings. A listing agreement is a personal services contract and cannot be assigned to another broker. The client hired a specific broker based on skill, reputation, and trust. If the listing broker leaves the brokerage or retires, the agreement does not automatically transfer. Instead, the brokerage retains the listing unless the client elects otherwise. For example, if a listing agent resigns, the listing remains with the employing broker unless the client signs a new agreement with the departing agent's new brokerage. Review summary. This section introduced the foundational legal concepts behind listing agreements. You learned that listing agreements depend on both agency law and contract law. Agency law determines who is represented and what fiduciary duties arise. Contract law determines validity, enforceability, and performance obligations. Listing agreements must be clear, written, and specific, with defined authority and compensation terms. They terminate according to general contract principles and create important obligations for both broker and client. All previous lessons on agency, fiduciary duties, disclosure regulations, and contract formation directly influence how listing agreements are drafted and performed. Discussion. Why is it important for a listing agreement to be in writing, even if state law allows oral listings? Answer. A written listing agreement protects both the broker and client by clearly defining the terms of representation, compensation, duration, authority, and duties. It eliminates confusion, ensures compliance with state regulations, and provides enforceability in court. Why is the listing agreement considered a special agency relationship? Answer. Because the broker is authorized only to perform specific tasks related to marketing and procuring a buyer, not to bind the client to contractual terms or act with general authority. The client retains decision-making power. How does agency law protect the client when a broker exceeds the scope of authority? Answer. The client is not liable for unauthorized statements or actions the broker makes outside the scope of authority. However, the agent may be liable for misrepresentation or breach of duty. How does the listing agreement connect to earlier chapters on fiduciary duties? Answer. Once the listing agreement is signed, all fiduciary duties, loyalty, confidentiality, disclosure, accounting, and obedience become legally enforceable obligations. The agreement activates everything you previously learned about agency responsibilities. Closing remarks. Understanding the legal foundations of listing agreements is essential to competent real estate practice. Every listing begins a formal agency relationship that carries both contractual and fiduciary consequences. As you progress to the next sections of this chapter, you will examine the various types of listings, their compensation structures, the advantages and limitations of exclusivity, and the practical steps for managing listings with professionalism and legal compliance. With these concepts in place, you are now prepared to explore how listing contracts shape the everyday business of real estate.